Good evening, everybody, and welcome to the School of Law. It's absolutely wonderful to see so many people here tonight, and I know that there are lots more people online. We're thrilled to be hosting the 2024 Society of Legal Scholars Annual Hale Lecture. We're thrilled that Hale is here with us tonight. This is the fourth SLS Hale Lecture. It is the 2024 one, even though it's 2025 now, because it had to be pushed back a little. Our speaker tonight is Sir Peter Fraser, Chair of the Law Commission for England and Wales. We're all obviously excited to hear what Sir Peter has to say, but before we turn to Sir Peter, I'm going to ask Paul Sterlica, who is Professor of Comparative Law at Bristol University and immediate past President of the Society of Legal Scholars, to introduce him.
Thank you, Alison. Thank you. It's a great pleasure to see you all here tonight. Thank you. And for those online, Croeso Aberdawe. And we are here for, as Alison said, Hale Lecture, which is a lecture held annually by the SLS, Society of Legal Scholars, in conjunction with universities across the UK and Ireland. And it's a great pleasure to be here in Wales tonight. The SLS lectures date back to 2009 to mark the centenary of the Society. But by 2019, the feeling was that we needed to move beyond the centenary of the SLS and actually recognise an amazing jurist and not name our lectures in her honour. And we are incredibly grateful to Lady Hale for allowing us to name our lectures after her, and also for attending and participating in this particular event. So thank you for that. Big thank you to Swansea for hosting today's lecture. The University of Swansea, as we know, is a key part of the SLS. We are very much a society that is in England, Wales, Scotland and Northern Ireland and Ireland. So it is good to reach out to be part of our wonderful society and our members in it. And again, good to see SLS members here today. Tonight's lecture is by Sir Peter Fraser. Sir Peter was educated at Harrogate Grammar School in Yorkshire, and then at St John's College, Cambridge, and has an illustrious career at the bar and then as a judge in the Technology and Construction Court and in the Commercial Court before taking on the important role of Chair of the Law Commission of England and Wales on the 1st of December 2023. We are truly delighted that he has agreed to be here tonight in Swansea to talk about the future of law reform. So Peter will talk for 45 minutes, then there'll be an opportunity for 15 minutes of questions in person and online, and then we invite everybody here present to a drinks reception afterwards. But let me give the floor to our amazing speaker, Sir Peter Fraser. Thank you.
Thank you very much. Good evening, everyone. It's a great pleasure and an honour to have been asked to come here to give the Hale Lecture. I would like to congratulate all of you for being so patient as Lady Hale, Stephanie Harding, my private secretary, and I were all stuck on the late running train, and I'm sure, however irritated and stressed we felt that we were going to be late, it was nothing compared to the stress and irritation that the organisers of tonight had as they realised they were depending on Great Western Railway to get us here. Thank you very much to the Society of Legal Scholars for inviting me to deliver this lecture. It is, and I mean this genuinely, it's always very humbling to see so many people give up their time to come and listen to me say anything, but it's particularly humbling to have Baroness Hale herself come all the way from London just for the evening, because she's going back again immediately afterwards, or almost immediately afterwards. And that's really rather remarkable, I think. And I hope that she doesn't feel her evening is wasted. She was actually at the Law Commission earlier in her career. I like to think that she's a great friend to the Law Commission. She was the first female Law Commissioner when she was appointed in the 80s. And it's very important for us as the Law Commission generally, in what is our 60th year, to reflect on how much society's changed. And that's one of the things I'm going to be talking about when I address you on the future of law reform. This is the 60th year since we were created in 1965. And the title of this evening is The Future of Law Reform. But because we can all learn from history, and there are some very distinguished academics who think that history, in fact, just endlessly repeats itself, I'm also going to deal with a little bit of history of the Law Commission as well, and law reform. But law reform did not, of course, begin in the 1960s. When Lord Gardner introduced the second reading of the bill that created the Law Commission, he said the following, and I'm just going to read a short extract out to you from Hansard, because it's so directly useful to consider the situation in 1965 and what was said about the reason for the need for the Law Commission or a Law Commission. And he said, the law is not a matter only of interest to lawyers. The law concerns every citizen in most of the daily aspects of their life. And if our law needs reforming, it is above all in the interests of laymen that it should be reformed. So the first question to justify the second reading of the bill is, does our law need reforming? And he then went on to explain really in quite detail why it did need reforming. And he gave an example of the number of different statutes that were on the statute book. And at that point, there were between 3,000 and 4,000 of them. And this is in the 1960s, before we had any of the acts that have been passed since then. And then to give an example, he posed a question that he'd asked two other very distinguished lawyers, which is quite a simple question, but it's got a very complicated answer, which I'm going to touch on. He said, where is our law on getting married contained? And the answer he then gave, which was a perfectly comprehensive answer, which I'm now going to take you to, is where it was contained. And there were 40 different statutes in which the law of marriage was contained. The earliest was the Marriages, Contracts and Consanguinity Act of 1540, the Marriages Pre-Contract Act of 1548, the Marriages Confirmation Act of 1804. There were then 11 different acts. They were all called the Marriage Act. That was up until 1840. We then got a sprinkling of a new title in 1860 when the Marriage Society of Friends Act was passed. Then had the Marriage Confirmation Act, another Marriage Society of Friends Act, a group of other acts that followed over the next 20 years, none of which had particularly dissimilar names. Some of them were the Marriage Act and some more were the Marriages Validity Act. I actually counted up on the train here how many Marriages Validity Acts there were, and there were 15 of them. They were all called the same thing. We then had the Foreign Marriages Act, so we're getting a little bit more creative. Some more Marriages Act, then the Marriages Legislation Act, then we had the Marriage with Foreigners Act of 1906, the Deceased Wife's Sister's Marriage Act of 1907, the Naval Marriages Act, then we're getting very specific, the Marriages in Japan Validity Act, the Marriage of British Subjects Facilities Act. Then that act was amended, the amended act being called the Marriage of British Subjects Facilities Amendment Act, but don't think about that. And then we got a little bit more descriptive with the Deceased Brothers Widows Marriage Act of 1921. And so it continues throughout the first half of the 20th century. I'm just going to give you a couple of examples of what happened. One called the Marriage Measure of 1930. I'm not sure what that was about. The Marriage, Naval, Military and Air Force Chapels Act of 1932. The Marriage Extension of Hours Act. I did actually read what that's about. It's actually about extending licensing hours if you were getting married, which in those days licensing hours were very, very strict. The Banns of Marriages Act, and so on, all the way through to the Matrimonial Causes All Marriages Act of 1944. And he then, in his speech to the House of Lords, said to them, I said to them, how long is this nonsense going to continue? And they said, well, it's all a matter of parliamentary time. Now, if you think of, and that's just one subject that really ought to be really quite straightforward, the law on getting married, and that example of where all the differences were, you can see the need for reform was fairly compelling. And Lord Scarman, the first chair of the Law Commission, said in 1973, it's very common to think law reform began in 1965 when the Law Commissions Act was passed at the insistence of Lord Gardner. This is quite untrue. Law reform has been part and parcel of the common law world since Henry II. And then he went on to note how the common law courts have been subject to reform since then. But really, the 19th century, which did see quite a lot of law reform, the way law reform was effected in those days is ad hoc reform commissions were established to look at the law in one particular area. And quite a few of them looked into how to improve the courts and judiciary. And the 19th century did see a significant consolidation of the statute book. All sorts of different provisions were amended and reformed, weights and measures, bankruptcy, shipping law, insurance, those sorts of things. And then in the first half of the 20th century, there was a body created called the Law Revision Committee, and then things started to move more quickly, but still, as at 1965, it was the personal energies of Lord Gardner who decided that a specialist body ought to be established. Now, Lord Gardner had been a committed reformer since he was at university. He was undoubtedly not only a great man, but he was very far ahead of his time. He was threatened with suspension from his university, from his studies, for publishing a pamphlet in 1922 with the scandalous title, which is a pamphlet attacking the restrictions on women undergraduates. And that was in the 1920s. So, as I say, considerably ahead of his time. And in the 1940s, after the Second World War, he was appointed to the Evershed Committee, which was a committee for examining and making proposals to reform the practice and procedure in the High Court. That took 9 years to produce 3 reports. On one view, its work could be described as painstaking. Another way of looking at it, and one which Lord Gardner has said was somewhat indicative of the need for more effective mechanisms to establish law reform. And one of the great law lords of the 20th century, Lord Reed, and I'm sure that all of you here who are students will recall some of his judgments, made the following point when he was speaking about the creation of the Law Commission. And he was referring to how law reform was being done at the time. He said, you really cannot expect good results from an ad hoc committee which has no adequate staff, meets only occasionally in the evenings, members of which cannot attend every meeting. It really will not do at this time of day to remit complicated issues to bodies of that kind. So once he became Lord Chancellor in 1963, Lord Gardner put into plan his action for a more systematic approach, which would not depend on the specific interests of individual parliamentarians. It was no longer to be carried out to an uncertain timescale, where there would be periods of stagnation followed by periods of frenetic activity, and law reform was to be considered in a comprehensive way, carried out by a permanent reform body, which was guided by a clear purpose. And that body for England and Wales was the Law Commission of England and Wales, and for Scotland it was the Law Commission of Scotland. And the Act itself says in the relevant section that the purpose is to take and keep under review all the law with which the Commission's concerned, with a view to its systematic development and reform, including in particular the codification of such law, elimination of anomalies, repeal of obsolete and unnecessary enactments, the reduction of the number of separate enactments, and generally the simplification and modernisation of the law. Now, those of you who are students at the moment, and this is something I'll come on to in a little while, if you want to look up the law on something, compared to when we were students, or I was a student, it's actually quite a lot easier for you in terms of statute, because you have a wonderful website called legislation.gov.uk. In my day, you had to try and find an up-to-date book, statute book. You had to satisfy yourself it was the up-to-date book. You then had to find what the provision was, but then check in a variety of unusual places to see if that was in fact the up-to-date provision. And some of the textbooks, which are in fact law reports I used to look at when I was a student, used to have tiny little bits of paper that were cut out, and the publisher of that particular law reform would send them out as updates, and they were stuck on the paper page by the librarian. And that was the way that you could find out what in fact had happened to that provision. So in a way, the internet has made that quite a lot easier. But the cynics at the time when we were created said, well, that's all very well, but Parliament's going to be unlikely to take up your reform proposals, and the Commission was effectively criticised for something that would be a worthy waste of time. We like to think that those cynics' expectations have been founded. From 1965 onwards, we have published 256 law reform reports, and 63% of those have been implemented in whole or in part, and a further 8% within their implementation expected. So we're in the low 70s in terms of our reforms being actually passed into law. Just in the last few years, and this is just to give you a very short shopping list of different areas that have led to different cases. In 2015, the law of insurance was significantly reformed under the Insurance Act 2015. That was a direct result of one of our reports. In fact, that report had the draft bill attached to it. We've had the Leasehold Reform Act very recently. That was last year. That was passed through Parliament in the last few hours of the Parliament before the general election happened in May, when there was only 24 hours to complete certain pieces of legislation, and that was one of them that got through. The team was sitting watching on the live stream, and for about 3 or 4 times through that afternoon, the House actually sat all the way till 11 o'clock in the evening. 3 or 4 times that afternoon, they thought, oh, we've lost the bill, we've run out of time, there's not going to be time for it. Oh yes, there is going to be time. Oh no, there isn't, and it was the last provision that was passed. The arbitration bill of 2024/25 is going through Parliament at the moment, and that's a direct result of one of our reports, as is the digital assets bill that deals with property. And another example very recently is the Electronic Trade Documents Act, which was based in relation to bills of exchange and bills of lading in electronic form. That was based entirely on a Law Commission report recommending that. So the Law Commission has been fairly successful. But no organisation should rest on its laurels. Complacency and basking in the reflected glow of your greatest hits, or in my case, somebody else's greatest hits, because I really only joined the band as the drummer in 2023, and obviously the Law Commission has been around for a lot longer than that, is not something that a reform commission should engage in. If the commission is to continue to realise its purpose in the future, there is, I believe, a need for it to be guided by certain principles or themes. And there's also the need, in our view, for one significant structural reform to the constitution of the Law Commission, which is what I'm going to deal with now. So I'm going to deal with the structural reform first. The Law Commission Act, it created the Commission in Scotland, which is organised differently to ours, and the Commission for England and Wales. England and Wales obviously dealt with collectively because that was a completely separate legal jurisdiction, separate from that in Scotland. It made sense for there to be a separate Law Commission in Scotland and a separate one for England and Wales. And the Act said that the Commission should be made up of a chair, who should be a serving judge, and 4 commissioners. Now, much has changed in society since 1965. When Lord Gardner presented the second reading of the bill There were 60 High Court judges, that was all, and now there are 108. The population have increased very dramatically since the 60s. The population of Wales alone has gone up by 500,000 people, or 20%, since the early 1960s. Population of England's gone up by 13 million. It was 43 million in the early 60s, and the census in 2021 shows that it's now 56 million. But we still only have 4 law commissioners. The number of commissioners has failed to keep pace with the increase in the population of the country, and it's failed to keep pace with the complexity of the law. It's also failed to keep pace with the fast-moving changes in society. Now, if you all reflect on how much society has changed, and I'm not talking only about the technological field, but the technological field is a good example. Lots of you will have one of these. If you printed out the code for a single one of these on A4 paper and piled the sheets one on top of the other, it would be taller than the Empire State Building. There's more processing power in a simple calculator, which costs you £20 from a high street stationer's, than there was in the whole of the Saturn V rocket that took the Apollo missions to the moon. Last night, I was lucky enough to be entertained to dinner by the High Sheriff, who's here tonight for good morning. And the wonderful car which collected me, the driver was telling me, you can actually drive that car without even touching the steering wheel. If you go on the motorway and you put in the relevant programming, the car will not only take you around corners, if someone else pulls in front of you in the lane, the car will slow down to give the relevant distance. And if that car then moves out of the lane, it will speed back up again to the cruise control. It will even, he told me, it will even go around roundabouts. Now, if you think of how society was in 1965, that's a pretty stark example of complexity and development. And we still have only 4 law commissioners. Also, since 1965, a lot has happened to the constitutional relationship between the nations that make up the United Kingdom. 21st century has brought and developed devolution. Obviously, the Welsh Assembly was created at the very end of last century in the Government of Wales Act. There was then another Government of Wales Act in 2006, which took devolution further, and the most recent one is the Wales Act 2017. And certain functions are completely devolved in Wales. Some of the justice, which is administered through society, is done in tribunals. It's not done in courts. And the Welsh tribunals are entirely separate from the tribunals elsewhere, and they're under a separate president of Welsh tribunals, who's Sir Gary Higginbotham, who was a former Court of Appeal judge. And this divergence has seen the Law Commission engage in detailed study of the law of Wales. Just as a couple of examples, we've examined the law as it concerned residential housing, specifically renting of residential properties in Wales. Those reports ultimately resulted in the Renting Homes Wales Act 2016. That in turn led to changes in the operation of the courts of England and Wales, depending on whether the rental property is situated in Wales or in England. There's separate provision in the civil procedure rules for claims between landlords and tenants, depending on whether the property is in Wales or in England. There are certain areas in which consideration of reform solely relates to those. And individual reform proposals have been matched by a broader approach by the Law Commission. So in 2016, we published a detailed report, which is called The Form and Accessibility of the Law Applicable to Wales. That project was proposed to us, the Law Commission, both by the Welsh Government and also by a body that was set up by the Law Commission, which is called the Welsh Advisory Committee. That was set up when David Lloyd-Jones, who's now Lord Lloyd-Jones, a Justice of the Supreme Court, was chair of the Law Commission in 2013. The chair of the Law Commission of England and Wales sits as the chair of the Welsh Advisory Committee, which meets twice a year, and that advises and discusses the law as it relates directly to Wales. All of this shows that it's necessary to have specific expertise in Wales or in the law of Wales. So far as we're concerned, these changes demonstrate that given the impact of Welsh legislation and the law in Wales, it makes sense to increase the resources of the Law Commission by having an extra commissioner with specific expertise in the law of Wales. There are parallels in other legal bodies, and I'll just give you two as example. The Civil Procedure Rule Committee, which is the body responsible for the civil procedure rules, has had its constitution amended by statutory instrument to require that one member of the committee must be a judge with particular experience of the law as it's applicable to Wales. The master of the rolls at the time that happened, now Lord Etherton, who himself was also a previous chair of the Law Commission, at the time of that statutory instrument said, given the impact of Welsh legislation on the criminal procedure rules, such expertise is as essential as it is beneficial. And the Civil Justice Council has also followed suit, and that has reformed its membership. And since that time has also had a member with a particular experience of the law as it is applicable to Wales. There's also another very obvious feature, and I say this comfortably, given that I'm in West Wales. Wales has its own separate language as well, and the legislation that's passed by the Senate is obviously passed in English and in Welsh, and that's yet a further reason to justify an increase in the number of commissioners that the Law Commission has. Each of our 4 commissioners are highly distinguished in their field. They historically, we organise the commission in the following way. They have defined areas of responsibility. So one is the Law Commissioner for the criminal law, one is for the public law, one is for property, family and trust law, and one is for common and commercial law. The current commissioner with responsibility for the law in Wales is Professor Alison Young. She was a professor at Cambridge before she joined us last year. It's not to suggest that the law in Wales is limited to public law, because obviously it isn't. But that is the way in which we have organised the different distribution of the law in those sections. And any of you who've studied any Roman law might notice that a similar split in the Justinian Code, but that's perhaps a lecture for a different evening, where I suspect if it was advertised widely in advance, we might not have quite so many people. Whether a 5th commissioner was specifically tasked with Wales, or whether it was just a 5th commissioner and internally we decided to reorganise it in such a way that that person had responsibility for the law of Wales, doesn't much matter. How it's badged, to use the vernacular, doesn't really much matter. I suggest that 60 years on, it's time for a 5th commissioner, and reform of the law and elimination of anomalies, and effectively keeping pace with society is one of our functions. And having our number of commissioners increased is akin to all of those purposes, I suggest. So I very much hope that that's a reform that will pass or come to pass before too long. It will help the Law Commission stay fit for the future, and it will demonstrate that although there are legal similarities between the 2 jurisdictions, the law of Wales, that there are also increasing divergences as well. So having considered that structural reform, I'm now going to come on to the other principles or themes which I believe should guide the Commission going forward in the future. First is economic growth based on the rule of law. It's well recognised that economic growth rests on the extent to which a country gives effect to the rule of law, and equally the extent to which the rule of law is observed internationally. I don't want you to think I'm describing the rule of law because it flows from economic growth or is a foundation. The rule of law is an incredibly important principle in its own right, but economic growth is one of its side effects or benefits. And the importance of the rule of law has been stressed in recent years by all three of our most recent Lord and Lady Chief Justices. As Lord Burnett, who was the Chief Justice before Baroness Carr became Lady Chief Justice in 2023, he said, the enduring lesson is that good governance and the rule of law enhance prosperity and well-being. And a commitment to the rule of law has several elements. Availability of high quality legal advice so individuals and businesses can understand their rights and obligations and properly order their affairs. Effective access to courts to resolve disputes via judgment, as well as effective access to other forms of dispute resolution process. Access to previous court judgments as a means to guide both of the former, and underpinning all of these factors is a framework of legislation, which itself is clearly stated and hence ought to be readily intelligible, readily accessible, and generally applicable. I cannot take any pride in authorship of that list because I've taken that from a book written by Lord Bingham, which was called The Rule of Law, and he identified those features as essential general principles. The rule of law also provides certainty. People and companies know where they stand. They know what's likely to be the outcome in any particular situation. And the rule of law promotes and demonstrates fairness and justice. An example of the way in which the Law Commission's reforms contribute to this, to maintaining legislative intelligibility and accessibility, and as a result also benefit economic growth, is one of our projects currently underway, reviewing the law concerning cooperatives. Now, we were commissioned to look at cooperatives by the Treasury. The cooperatives happen to be very dear to my heart. For part of my childhood, we lived in the north of England. Cooperatives are part of the structural fabric of society, particularly in areas like the north of England and also in some areas of Wales. Their origin is groups of people who are often of lower economic means, who group together to help each other and to try and share the economic benefits of trade and mutuality. There are significant potential economic benefits from reform in the area of cooperatives. I'm going to quote to you from our consultation paper, which says, cooperatives are associations of consumers, producers, workers, or a mixture of these. Part of their purpose is to harness economies of scale. When producers or workers combine as members of a cooperative, the cooperative might command better prices in the market for the produce or labour. And when consumers combine as members of a cooperative, the cooperative might access cheaper prices for goods or services, and the cooperative can then pass on those better prices when selling to its consumers, buying from producers, or paying its workers. So just to use a real world example, if you have a group of small dairy farmers, each of them individually would not have a particularly strong economic market for their milk because they don't make it individually, they don't produce enough. But if a group of them get together and form a cooperative, then they have much better bargaining power and will usually get a much better price. And reform in this area can help result in increased competition between cooperatives and also between cooperatives and other businesses. That will facilitate growth through the economies of scale, which such increased competition can lead to. And that in turn will lead to further increased economic benefits for the members of the cooperative. The people working for the cooperative will get higher wages. The lower prices that generate from economic competition will benefit the economy. And all of this actually helps the Treasury, which might well be a cynical person might ask why they asked us to look at it in the first place, because they'll get increased receipts from taxation. So simplification and modernisation of the law in an area such as cooperatives can have significant benefits. And another project which we're launching later this year is reform of the law concerning the agricultural sector in Wales. I'm not going to go through that in any great detail because there's a very long list of statutes with very similar names. They're not quite as many as there are on marriage, but there's still quite a few. The earliest one is the Field of Agriculture Act of 1889, and it goes all the way through to the 21st century. So you can imagine there's plenty of scope for complexity. There are over 30 pieces of potentially relevant legislation in that area, which just by its very feature of that number shows you that anomalies will have sprung up, and legislative complexity increases economic burdens placed on that sector and on farmers. To improve matters, we are considering the potential for codifying the law in that area. And in doing so, we will consider how to simplify and modernize it. It's based in a certain number of phases, and depending on what the outcome is in the first phase, depends on what will happen in terms of the development of a new agricultural code. But if you think of the benefits of a code takes together all those different disparate parts, pieces of legislation. It puts them in simple, modernized language, all in one place. And given that the code becomes the replacing piece of legislation, if there are needs for amendments going forward in the future, the only thing that needs amending is the code. So it becomes much more straightforward and helps systematic review development. And it also helps reform to be much more efficient. So it makes the law clear, simple and comprehensive. And in doing that, the Law Commission is obviously doing what it considers is helpful towards improving the rule of law and also reducing something that the economists call economic friction costs, which are things that arise through legal compliance. And if you think of the scale of, just to use that example as a worked example, a farm, at one end of the scale, you'll obviously have an enormously economically powerful farm with many employees. It might even have its own legal department. It will employ lots of people. But at the other end of the scale, you've got much smaller scale farmers. A farmer on a hill farm somewhere who might not have a particularly powerful economic operation, he or she ought to be able to look up what the law is in a particular area and understand what it says. And that's just another reason for the benefits of codifying law in particular areas. So those are just two examples. That's why our purpose is, and will continue to be, really something that can be summed up in a simple sentence, which is a commitment to improving the rule of law by reforming the law, making recommendations to reform the law. It's obviously Parliament that decides whether to turn our recommendations into law. So coming to the next principles that guide our work, the two which I'm going to deal with first are legal certainty and transparency. These are inherent in any commitment to the rule of law. Continuing what might be thought to be one of my pet subjects, which is codification. The first can be illustrated by a very significant piece of codification which we did in 2000, which is the sentencing code, criminal law. That provides guidance on the available sentences for criminal offences in England and Wales. I know some people in this room sit either as part-time judges or as magistrates, and they will know that sentencing can be highly complicated. The sentencing code consolidated over 50 pieces of previous legislation. It simplified and updated the law. It removed some of the anomalies. It removed the ambiguities, but it also made the law transparent. And it did so through increasing legal certainty. Criminal sentencing is obviously an incredibly important area. It affects individual liberty, it affects public safety, it affects the well-being of society. And a lack of transparency and certainty, where criminal law in particular is concerned, is something that must be avoided really at all costs. And in Lord Bingham's book, which I mentioned earlier, he gives an example of a case in the mid-90s where the judge in question wanted to impose a community service order on somebody. The case went on appeal because there was a question mark about whether the individual had been properly convicted. And on appeal, the Court of Appeal wanted to uphold the conviction and the sentence. And all of this was based on regulations that had been brought in to force in 1992. The trial judge, prosecuting counsel, defence counsel, and not one, not two, but three judges of the Court of Appeal had all missed the fact that the 92 regulations they had been banking everything on were no longer in force and had been superseded. Now that is a very good example. I hasten to say I wasn't. No, you weren't but that shows you that the sheer mass of legislation in the area rendered it effectively impossible, even for those highly qualified people, never mind the public, to know what the law was and apply it. So complexity created by so many different pieces of legislation dealing with the same subject plainly rendered the law less transparent. And for the reasons that I have explained, one of our purposes is to increase and improve transparency. The second aspect of transparency concerning our work is the way in which we arrive at our recommendations. And I gave a lecture yesterday at Trinity St David's, and I said, and I've seen some of the people here tonight who were there, and I have to say, I admire your stamina that you could come to. Although they did check with me as we left last night that I wasn't giving the same lecture 2 days. But I explained this to them, and I want to explain it all to you. When we are considering any subject at all, we engage in really very extensive consultation. And in doing that, we wish for as many responses as possible, not just from specialist stakeholders or people who've got a vested interest in that area, but from members of the public, from law students, from lawyers, from academics. We very definitely welcome it. And we have done this as a commission since the very first working party that was set up in the mid-1960s, which considered reform to freehold title. In order to arrive at their recommendations, the Law Commission in the 1960s consulted with the conveyancing profession because they were the people who experienced and encountered day-to-day difficulties of practical consequences of what the law was on conveyancing freehold title. And in those days, that sort of engagement was encouraged by publishing, the Commission publishing in the New Law Journal. Ensuring transparency in any way at the most basic level is a way to secure high quality and breadth of feedback on what our proposals might be or what different people's views are. It was and is a means to improve our working. It can draw our attention to unforeseen adverse consequences that some of the consultees might have anticipated or come across themselves. It contributes to the quality of our proposals. It's, in our view, we consider it essential, and it's a way of us making sure that our proposals will promote legal certainty and not lead to further complexity or confusion. We make considerable efforts to ensure that when we are engaged in a project, we consult as widely as possible. And I encourage everyone, and I literally do mean everyone, particularly everyone in this room, but other people who you might know who aren't here, to participate in our consultations. They're entirely public. They're published on our website. We welcome contributions from members of the public, whether they're legally qualified or not. We have a big project underway at the moment on criminal appeal. That's going to be published later in February. Subject of the lecture that I gave last night was criminal appeal, but it applies to you as well. Please keep an eye out on our website look at the document, the report, and the bill, and tell us what you think. It's a very formalised way for us to gather as much information as possible, and we welcome it. But there's a deeper reason why our processes must engage with the public in that way. Law reform is an important part of the democratic process. It's as much a part as law reform is a democratic activity in the same way that other democratic activities such as voting in general elections, etc. Our contribution to democracy arises at an early stage of the process. Because of that, we have to ensure we fully engage with members of the public so that you, we, us can all be seen to be a part of the process. That being said, we are very definitely aware that the way in which we engage with the public in this area is something that has to keep up with the times. Publishing in the New Law Journal is probably not the way to do it now. I'm not saying we shouldn't do that, but we obviously need to do other things as well. Publishing on our website is probably also not the most modern way of doing it, although we need to consider doing that as well. We need to make potentially a greater use of social media. We are considering whether we need to start or ought to start a podcast series. There are all sorts of different ways of us trying to demonstrate modern engagement with society. But however it's done, we consider that it's fundamentally important to take steps to maintain our relationship, not just with government department, and the judiciary and the legal profession, but members of the public as well. And our work should have a positive and constructive relationship with all our audiences if we are to continue to improve the quality of the law. So just as we're required to modernise the law, I think we must also modernise the way in which we engage with people in the process of law reform. I'm now going to turn to the final three principles. These focus on ensuring, firstly, that the law promotes individual well-being whilst also protecting the vulnerable. Secondly, that it delivers innovation and enables new opportunities. And finally, delivers value for money. I'm only going to touch on these very briefly, and there's less black letter law to be said about them, but we still consider these to be important principles. I've mentioned earlier how important legislation can be for promoting economic growth and the rule of law. But as I said, I don't want you to leave this evening thinking that the Law Commission is guided by a neo-utilitarian approach, or that we consider our proposals by reference to an economic cost-benefit analysis. Because although those are relevant issues, there's much more to law reform than being guided by an economic imperative. Laws must respect individual dignity and promote individual rights and responsibilities, because the intention of them is to provide a just framework for social as well as economic development. And they must be just for everyone, because everyone is equal before the law, and that means they must also take into account the vulnerable. So there are some projects we're doing. For example, we're doing one at the moment on kinship care. Those projects are just as important as other commercial ones, which focus on legal or society innovation, such as digital assets in private international law, or electronic trade documents, or things of that nature. As another example, we're currently considering the law on burial and disposal of the dead. That's not being done for economic reasons. And there will be economic implications for what we decide. And just to give you a snapshot into one discrete area in that project, reuse of burial plots or reuse of burial grounds in an increasingly crowded society is quite a thorny and delicate issue, but it does need grappling with, and we consider we are the best people to grapple with things such as that. Lots of different people will have a range of different views. Many of those views will be influenced by their personal experiences. They may be influenced by their religious beliefs. And whichever recommendations we make in that area, we're not going to be guided by the greatest economic benefit at all. It's increasingly likely, as the last 10 to 15 years has demonstrated, that we will have an increasing focus on modernisation in the light of digital developments. I'm not going to go on at length or even mention, other than passing, artificial intelligence. I've already referred to automated vehicles. We've done quite a lot of work on digital assets. There's also thorny issues connected with product liability and software, and also generative AI, which, as you know, software that teaches itself to improve, and other really quite complex issues such as that. As we approach that sort of work, we'll approach it to, as far as we can, promote rather than stifle innovation, do so in ways that deliver value for money for society, but also protect individual rights. And given the benefits to the economy in having a strong rule of law, as I've said, and the way in which our work over the last 60 years has contributed to that, I hope the case for delivering value for money is more than made out. We are actually a very small organisation. We have fewer than 70 staff. Some of those are part-time staff. We occupy a tiny part of one floor in the Ministry of Justice building in Petty France. Our budget is really very, very small. And I don't just mean in comparison with government budgets generally, I mean in real terms it's small. But we deliver benefits far out of proportion to the cost of the Commission. The Electronic Trade Documents Act of 2023 that I mentioned, we have to do an economic impact analysis, which is done by separate independent economists. It's not done by us, thinking of a number, but all the reports and recommendations that we do. And the economic impact analysis of the Electronic Trade Documents Act was calculated in many billions of pounds over the next few years. And that report cost a couple of £100,000. So we think that we deliver very significant value for money. But with those points in mind, I want to end today's lecture by recalling something that the very first chair, Lord Scarman, said in a lecture when the Commission was in its infancy. And he said, when he was considering, as I said, the cynics who said, well, it's going to be an expensive waste of time. He said, I would say to you, who are the lawyers of the future, it's in about 10 or 15 years' time, take a look at the Law Commission. Has it become just another Department of State? If so, get rid of it. But if it hasn't, continue to give it your support. So I would pose the same question to you, because in this room, we have a great many lawyers of the future. Who knows? We may even have a future president of the Supreme Court in this room, a future chair of the Law Commission. There's no reason why that shouldn't be the case. Society has changed very considerably in 60 years. 60 years ago, I can guarantee that someone in my position would not have been the chair of the Law Commission or Law Justice Appeal. I wouldn't have been a High Court judge. I'm the grandson of a miner. My father left school when he was 16 and my mother left school when she was 15. And society has moved on very significantly. And there's no reason why any of you, any one of you, couldn't be standing here in 30 or 40 years. Well, 40 would be a nice round number, then be the centenary. If any of you are chair of the Law Commission, I hope you'll promise yourself that for the centenary you'll come back here to the building. Ask yourself that question. When Lord Scarman posed the question, he didn't speculate on what the answer might have been, although I'm pretty confident that he would have hoped or anticipated it would be a positive response. I think the answer to the question can be much more confidently delivered. The Law Commission is certainly not another Department of State. I like to think, and as far as I'm concerned, the statistics probably bear this out, But as somebody who's from time to time been criticised for being overly concentrated on data, there's obviously a bit more to it than the statistics. But I like to think that having looked at the 60 years of the Law Commission and asking you that question, is it fit for purpose and is it ready for the future? Is it going to continue to reform and improve the law? That the answer will be yes, and that you will continue to give it your support. And I'm entirely confident that as the years unfold going forward, it will continue to play a valuable and essential role in reform and development of the law of England and in Wales. Thank you very much.
Thank you so much. That was a really inspiring lecture. It gave us a good understanding of what the Law Commission of England and Wales is about, and also the challenges for the future, particularly with technology, but also, as you say, getting people involved at a grassroots level, but also, as we said, looking forward to future law commissioners coming out of the University of Swansea. We've got a short period of time, we're slightly behind schedule, but we would like to take some questions if we have questions. And we could look online as well to see if there's any questions. Anybody in the room?
Thank you so much. I had a question. What is the role of the Law Commission in terms of maybe reforming the law, holding the UK government and private parties within the UK accountable for climate change? We see based on case law that it's very difficult to hold especially governments accountable across the board from the Netherlands to the UK and America because of legislation that is missing. So the Climate Change Act is a nice, initiative, but it's more setting a target and not holding individual companies, parties and the government accountable to really reach those targets.
Well, I'm afraid that part of my answer you will find somewhat dispiriting, because it's not our job to hold the government to account. Insofar as the law needs reforming in any particular area, and that includes the environmental field, we have got environmental law projects in which we consider that. Once those laws are passed and or any regulations that are subsidiary to them are issued as well, whether the government of the day or any particular state or private body comply with them is really not our job. So that might not be the answer that you were hoping for, but possibly is the one that some of you were expecting, I'm sure. But we are fully aware of the importance of climate change and all those sorts of environmental issues, and we do look at environmental projects regularly, and we've got some underway at the moment. I can't give you an exact list of them, but it is one of the things that we look at. In fact, I was earlier today discussing environmental law in Wales with quite senior people, so it is something that comes up.
Any other questions? We have one online, Alison. Can you, I can't see it, so could you?
There isn't anything.
There isn't anything, okay. Yes, please.
Peter, I'm a computer scientist, so I've inevitably got a question about.
We have met before, I think.
We have, yes. You told us law is really complicated and there's an awful lot of it. And you also made the analogy with something like my phone, which has got millions of lines of code. About 20 years ago, computer scientists noticed something. The 20 million lines of code pretty much works very well. And how we get complicated things to work is central to computer science. Computer science is about managing complexity, which is exactly what you need to do too. And it's got a name, it's called computational thinking. It's not about building stuff, it's about understanding how it computes in the broadest sense of computation. So are you thinking of using computational thinking?
I like to think I personally engage in computational thinking all the time.
You do, it's called computational thinking.
It is one of the things that's discussed. It hasn't been initiated. I mean, there are various projects underway generally at the moment, as in this month, this year, along those lines in all sorts of different all sorts of different legal avenues. We don't actually do it ourselves at the moment. I can certainly see a time when it will start
But
happening.
I think it means I would argue, of course, that you need to start employing people who've got computer science degrees to manage the complexity.
Well, that's probably right. I think we do have some highly skilled computer scientist-based lawyers. At least 2 of them I can think of, I'm pretty sure, have got computer science degrees. And we've also got at least 2 academics with quite a lot of exposure and experience in that area, as I'm sure you also. The lady over here had a question, I think.
It was about the surrogacy law reform report that was done in 2023.
Yes.
The government are quite a bit over their year to respond. I just wondered whether, firstly, you expect to get a response, and when a response doesn't come from the government, what steps are the Commission able to take to push them for a response?
Well, the answer to the first part of your question is we are expecting a response soon. We're well aware that it's overdue. I think they're well aware that it's overdue as well. And part of the reason for that was caused by the election, I'm sure, last year. But it is something which is very definitely at the forefront of our radar, if I can make that course. If they don't respond within a reasonable to medium time scale, then there are ways that we can encourage a response. It's a sort of cascading order of, I suppose, soft persuasion moving towards hard persuasion. I'm sure none of that will be necessary. It is, I'm not making excuses for the fact that they haven't responded yet, because obviously any government, particularly a new government, has got quite a lot on its plate. But we're well aware of it, and hopefully it will be soon. I'm very impressed that you're so up to date with not only our current work, but the timetable for formal responses. If I had a prize for the best question, that would be it.
You want one last question that can pick and win the prize? We'll see who was.
Don't know about that. Thank you for the lecture. I really enjoyed it. You may know that some of our work here at the School of Law is on children's rights. And what we know is that children are often excluded from the sort of democratic processes that you talked about, most obviously from the democratic mandate. And we know also that law is incredibly important to children now and the future adults that they will become. I wondered if you had any thoughts on the importance of listening to children in the work of the Law Commission, and any thoughts or insights into how you might go about engaging with children in your work?
Well, there's one project which is underway at the moment, which is on disabled children's social care, which is solely about children, though obviously not all children. And then there's another project that's underway or coming towards a significant milestone, which has very much at its forefront on one of its major issues, children's rights. It's something which the teams and the commissioners are acutely aware of. They are very much in favour of increasing, where relevant, and justified children's participation in children's rights. They engage with the different children's stakeholders through a variety of means, including quite a few children's charities. And it's something which it's discussed a lot. And that might sound like a relatively superficial answer, but it is true. And I have been in meetings where the rights of the child are debated really very significantly, and I've learned quite a lot more about that technical subject than I knew before I became the chair. So it is something which they're very aware of, and in the Disabled Children's Social Care project, they consulted very widely, not only with the parents of disabled children, but also the children themselves, where they were able to, and as a result got a very deep understanding of the sorts of real problems. And that actually is another good example of complexity. I gave the example of the farmer, the small farmer who needs to be able to look up the law. What we found when we were doing the Disabled Children Social Care Project is parents of disabled children are in almost exactly the same position as my hypothetical farmer. The degree, the number and difference in some very significant statutes is quite incredible. And if you put yourself in the position of a parent in that situation, you really need to be able to find out what the law is in any particular area, in really quite an accessible way, and that's just not possible at all at the moment. So we're not in the position of making recommendations yet because the project's underway. But one of them, at one of the milestone stages of the project, it's very, very obvious to me that, in fact, that project is under the Public Law and Law in Wales team. So it's Commissioner Young, particularly to her as well, how much it needs reforming.
Thank you.
Okay.
Well, thank you for answering our questions, and thank you for a really inspiring speech, which I think has opened up to particularly the students here, the exciting work and dynamic work of the Law Commission and the future of the Law Commission as well, which we're very, very grateful for. So thank you very much.
Absolutely.